Well, I think we just got the go-ahead here for
To take it from the top.
from the top. So today we are in a very unique setting here with the newest addition to the law offices of Plano and Farrow. Aimana El-Bahtity, welcome to the 6-Minute Increments, as she is remote here from Orchard Park, New York, and we are in the Focus Practice Management Studios. Welcome to the show.
Thank you. Thank you for having me.
So the unique part about you, why we thought you would be perfect for this, is the purpose of 6-Minute Increments was to look at the role between law and business and give people a perspective of both sides. And the unique thing about you is you've actually been sitting on both sides of that fence for quite some time.
Correct. Yes.
Why don't you tell us a little bit about your background and how, one, you got into law, and then how you got out of it for a while up and until now.
And then you got back into it.
Right.
Right. No, that's great. I would like to think that I remained within law, and that law is just a very broad, profession that allows you to dabble into different ranges of practice areas. But that is accurate. Yes, I did start conventionally in law firm practice right out of law school, and practiced in the insurance fraud defense arena in the downstate region when they used to do stop and squats, staged accidents. Not as common here in the upstate area. But that was very interesting because that actually helped me pivot into almost like a healthcare scope. So I would say that thematically, even though I was in conventional law and then went out onto the business side for some time and have come full circle back into a law firm arena, I've always thematically practiced in healthcare. I will say that after I was in downstate New York at an insurance fraud defense firm, I also had the pleasure of practicing insurance defense, more corporate litigation in Chicago. But in that instance, the insureds were large pharmaceutical and research development companies. So I was acting in a capacity of serving to issue insurance determinations or a coverage analysis. And essentially, we would disclaim coverage on grounds of expected or intended outcomes if there
You
were
were that
adverse health
person.
outcomes. I was that person.
You're that
It was
person.
very interesting work, especially in light of recent current events.
Yeah.
The work that you're doing is essentially looking at drugs and adverse health outcomes and saying, well, wait a minute, is there a link to this? Could there be grounds for expected or intended outcomes, which would serve as a basis for a disclaimer of coverage? And then I moved to DC, and I had the honor of working at the U.S. Department of Justice for a brief period of time. And I would say that's when I started to remove myself from conventional law. And I was actually working in almost like a claim scope where I was advocating on behalf of NYPD and FDNY officers who are unfortunately dying today as a result of their exposure to the fallen World Trade Centers and the contaminants that were in them at that time. And if you can imagine, when providing compensation determinations, you have to establish eligibility at first, of course. And so you are looking at a series of health conditions that are codified by the World Trade Center Health Program that make them eligible. But that's where I really started to fall in love, if you will, with the merger between healthcare and law. And so when I had the opportunity to go to the DC Office of Risk Management and work on their healthcare side, also in a claim scope, I welcomed it. It wasn't until really recently, after returning to New York and practicing as an executive director for 2 healthcare organizations since the pandemic, that I then came across this opportunity to actually come full circle and be back in conventional law, which I think is great because now I have the ability, although I have left conventional practice and I'm back in it, to leverage my background and bring that to the table in terms of allowing the business side to merge with the law side, have an understanding of what is important to the stakeholders you're serving, and so that you can get ahead of and exceed their expectations.
So the show's called 6-Minute Increments, and I know that for myself, as having sat as an outside counsel person, one of the best parts of that was no longer having to track your time in 6-minute increments. And I know we had this conversation that you thought perhaps this was only a 6-minute show, which we know it's not, but it's how we bill our time. Well, how do you find that as you're getting back into the private practice of law, you're acclimating to the timekeeping requirements as part of your job duties.
And it's absolutely the worst part, right?
It's terrible. It's why people
Yes,
leave
I
the
mean,
private
you
practice
know,
a lot.
to be completely frank, it's certainly an adjustment that I did, almost try to brace for impact on because I do vaguely recall what it was like ages ago. Of course, I also am one that's very realistic in terms of understanding that things have evolved and changed. So just not knowing what I don't know too is another
Right.
variable that contributes to, uh, just that those new jitters that you have with returning to conventional practice. But absolutely, it's an entirely different animal, and you have to almost shift your mindset, trying to quantify everything you're doing when, you know, conventionally, when you're out in the business side, a day's work is a day's work. And of course, you
Right.
hope to make a positive impact, but you don't need to quantify every minute, essentially.
Well, I
Right.
know that today, I'm kind of curious to get your take on an issue that today is the second day of the New York State bar exam. Shout out to Brady Andrews. I hope he's doing well from Albany Law School.
And good luck to everybody.
Good
taking
luck to everybody today.
Yes, for
But
sure.
in your transition from the private practice, as you went into the government role and you went into those executive leadership roles, how did you find that your legal training, your legal background helped you in those roles? It's one thing to say coming back out, how the business side might help, but what about being a lawyer? Because I think a lot of people don't grasp the breadth of opportunities. Could you speak a
For
little bit to
sure.
that?
And that's spot on in terms of characterizing it as the breadth of opportunity. I actually, my takeaway with law, really, from my experience, has been that it's a blessing because it's so broad and it gives you the opportunity to keep your hand in various scopes and to still be a cut above the rest, if you will, because you, as an attorney, learn how to think critically and in many ways outside of the box when you have to pivot on behalf of an organization. I will say that most recently in my scope as executive director to both the Medical Society of Erie County and New York State Chapter 1 of the American Academy of Pediatrics, I was sitting in almost a physician advocate role where essentially, and also a patient advocate role, but where we were trying to streamline outcomes to enhance patient outcomes, right? And a lot of that had to do with an understanding that I developed through my practice of law in terms of understanding, adverse outcomes and a liability that attaches, and why doctors would feel so concerned being in a litigious state such as New York. Um, and it positioned me to be able to effectively serve their needs because I will say that there are a series of unfortunate circumstances when it comes to the state of New York and medicine. We were just ranked 47th in the country as one of the worst states to practice medicine,
Get
and that
out.
is nope, that's a
I
Wallet
did
Hub
not know
study.
that.
Yeah, those are
The
fun
great
facts
state of New York.
right.
We've got all these medical schools.
We train a lot of people, but there are many reasons
They never
why it is
leave.
not a
They never
positive place to practice.
Wow. I did not know that.
And that really is because payouts to plaintiffs in malpractice suits are highest in the state of New York than any other state.
Wow.
Doctor, and of course, it's very regulatory. So there are a lot of barriers to healthcare delivery in New York that has resulted in essentially an exodus of physicians from our region. And what I was doing in the latest scopes that I was in was trying to basically advocate, and take resolutions, draft them, send them to a House of Delegates, escalate it to legislators, advocate on behalf of not just the preservation of the profession of medicine and overcoming barriers to healthcare delivery, but overcoming delays to patient care so that we can ultimately enhance patient outcomes in the region. And this is precisely why currently New York has such grave access to care issues, because essentially many of our physicians, just like Brett said, they'll come to university here, but then they leave to practice elsewhere.
So on that advocacy front, I mean, what about, I guess, being in law school, going through your past, helped you to even do that? I mean, what was the
Or did it help?
or did it? Maybe it didn't.
You're
Maybe
assuming
were
it
like,
helped, but maybe
yeah,
it was a hindrance
that's
that she had
true.
to unlearn.
Right.
You know?
Get rid of all that
Yeah.
nonsense that law school
No,
taught you.
actually, it was very helpful in
Ah!
terms of, well, because if you even think about the beginnings of wanting to make change, right, you are really looking at perhaps identifying issues in need of resolution and then coming up with resolves, right? Or means to overcome those issues. And that is the makings of a resolution in which, and that is the underpinning to a bill. Because when you can basically, and that's what I was doing, was collaborating with stakeholders, clinicians, to identify the issues that they were seeing that on the front lines to healthcare delivery, ultimately so we can enhance patient outcomes here in the state of New York. And then I would escalate those resos once they were drafted, which were a series of whereas clauses and resolves that would then go to almost like a delegation. It was called the House of Delegates. And once those were approved, they would be oftentimes used as the meat or substance to a lot of the bills that are being created today. So for example, one of them was the Gold Card Act. Okay, so here in the state of New York, oftentimes you're faced with delays in care because you need prior authorization. And I had leveraged my legal background by knowing, well, wait a minute, if I know that there are a series of legislation that exist in other states and they're tried and true, I can bring it to a legislator here in the state of New York and make the case for why it's already tried and true, and they can replicate it and enact it. And that's ultimately what happened with the Gold Card Act. It was a statute in the state of Texas enacted years ago that basically said to insurance companies at large that if you have approved a procedure 90% or more of the time after a request for prior authorization, then too bad, so sad, you can no longer deny that request and you must approve them going forward. And that overcame so many delays in care, which ultimately enhances patient outcomes. And so I brought that piece of legislation to Senator Kennedy at the time. He had sent it to, he had Senator Breslin sponsor it, a Democratic sponsor. And then a year later at Advocacy Day, I had the opportunity and privilege to meet with Republican Senator Gallivan, shared the same sentiment about the Gold Card Act, and it became bipartisan supported later that day. So I would say that, there's a lot of empowerment that comes with being a lawyer, and I think that it allows you the ability to empower those around you. And that's how I've sought to leverage our background of law within any scope that I've been in, even if it's not conventional practice of law.
Now, as you talk about bills and writing bills, there's a whole different side of bills that we in the private practice have to deal with, which I'm curious in your executive director leadership roles, how often did you ever get and have to engage outside legal counsel and get their bills? And then now that you're about to send them out, what is your thought about keeping track of time and billing clients? And what have you learned about engaging with clients about their bill? Because that's by far one of the biggest pushbacks I think that we get in our lives is, what is the reason for this bill?
And that's precisely it. I think that what I've learned from the business side is realizing just how many variables or how many steps it goes through before a determination can be made. I would say that when I was on the business side, if you receive a bill, at least when I was in the nonprofit organization, I reported to a board, right? And so that was, approval of certain amounts that exceed a certain threshold, or just having a meeting of the minds for a set rate. You didn't many times have the ability to act unilaterally. So sometimes that would really create a bottleneck in approvals. And so I could see how that would create issues on the legal side, because it's not like you are just dealing with one stakeholder. Oftentimes you do have to deal with other individuals that have to weigh in. I will say that it would likely, that's a great question, because now I'm realizing that I could use that to my benefit to
Right.
look to how I would couch my billing. Or
All
to
clients
just
out there should want to get a bill from you because it will be thought through in that perspective.
Yes.
They
Yes,
should clamor
yes.
for a bill from you.
And to be sensitive to, okay, what were specifically the client's needs, and did I deliver within this transaction? So yes.
Have you, you're just getting back into it. What part of seeing your own bills and your own billing time are you most dreading or looking forward to? I like to see the people when they come out and start to practice law, the first bill they get that has a good amount of their time on it and the number at the bottom, usually causes sticker shock for them. Are you ready for that?
Yes, I mean, that's just it. I think that it's just about reframing your mindset because you're not used to seeing a quantified value attributed to the time that you're putting in. You just put the time in to get the work done and to obviously do it well and make an impact. So that is an adjustment that I am having right now. We just converted to even a new database, today, and it's front
Today?
and center. Right, and it's neat because I'm grateful that I came on in time to be able to get up to speed with the system at the same time. But I will say that I just put in a few entries today, and right front and center, it shows you that quantified value. So that's something that is a bit of an adjustment. But then it also makes you sensitive to, okay, then, your efficiency, right? So that's really something that I'll have to get used to because I am the type of person that when I'm asked to do something, I don't want to just get it done to get it done. I want to get it done to get it right and to make a positive impact.
Yeah, I think that's a great point. You point out that it takes a certain amount of time to get something done. Yeah, and you want to make sure that it's right, and your clients want to make sure it's right. At the same time, you're trying to look at your own efficiency. The two don't exactly always meet in the middle. As you sat on the business side, how did you interpret the balancing act that I think lawyers go through trying to show value to their client? I mean, what thoughts or tips do you have for lawyers or other people out there who are maybe even analyzing the bill? How do you analyze the bill to see whether you got value for your money?
Well, I think that it really helps that I am an attorney myself because I was sensitive
It
to
is
the
harder
receipt.
to fool the attorneys, I'll say
Yeah.
that.
But I was also sensitive to the receipt of any of those bills and understood what went into it as well.
Right.
Oftentimes when there's on the business side stakeholders who are not attorneys, but they see that there is an executive director who's an attorney, they will think, okay, well, then they can handle it all. And then, they don't see the value of outside counsel. And I was always one who managed those expectations like, no, just like, for example, since we're in healthcare, I'll give that analogy. If I had a heart problem, I'd go to a cardiologist. I wouldn't go to a neurologist, right? So not all attorneys practice the same scope, and not everyone's a subject matter expert in each scope. So if anything, for me, I was always trying to manage the expectations of the folks that I was working with to let them know the real value add of having a subject matter expert in their particular scope. I think that helped me, and I was kinder to the receipt of the bills or any bills that we would receive. Um, but also because I was able to lean on them as subject matter experts. And so I truly appreciated their value and what they brought to the table because I knew unilaterally I could not, deliver. So I would say that, it was something that worked for the benefit of attorneys when I was in that scope as an attorney myself, because oftentimes you will find on the business side that if someone has an ESQ at the end of their name, they're thinking, well, we don't have to go outside to outside counsel. You could just handle it.
Right.
And that's not the case.
Well, I think that's also even for the three of us as we sit here. I guarantee at some point there will be an outside party who'll be like, why are the three of you on this meeting or in this call? And we bring three different knowledge bases to the table. It definitely happens
For
regularly.
a lot of our clients, it wouldn't be unusual to have a healthcare lawyer, a corporate lawyer, employment lawyer, in on the same call.
But then they get what we will all see today, triple billing.
Right.
Which is why we don't want to make this go too long today.
Yes.
But I guess if you did have any parting words of wisdom or things that you're looking forward to as you get back into the private practice of law, dealing with clients, having clients think about you, what might that be?
Well, I would say that, even in my most recent scope where I was saying I was on the business side, I wasn't in conventional law, I was working for a healthcare trade organization. And I will say that having sat in that seat and working oftentimes with, it was actually on behalf of MDs and DOs. So it was all a physician organization. I did get an intimate understanding of what issues were important to clinicians at large these days, especially as it relates to, for example, employment contracts. And the concerns about restrictive covenants or non-competes, the concerns about I've seen battles play out about a doctor who's leaving a practice and thought they'd be fine leaving with their patient population or patient records. And nope, too bad. So, you did not. And so I think that in that scope, I was able to see firsthand, because I was working hand in hand with these physicians on advocacy matters, just what was important to them. And I think that what would be great is that I can now leverage that rapport that I've developed with the physicians and the understanding that I have about the barriers to healthcare delivery, as well as all the concerns stemming from a contract that's not done right at the outset, and bring that to the table here in a firm setting. I will say that my one primary takeaway, for example, you can't really cut corners when it comes to physician employment contracts. You will always, in terms of cost benefit analysis, pay far more than you would have saved if you don't get it right on the front end. So I'm a huge advocate of legal sufficiency review. Every doctor who's on the front end, every doctor who faced a dispute, for example, leaving a practice and thinking that they could have left with their patient records, absolutely regrets not having, a legal
Contract
expert.
review today keeps the litigator away.
Yes.
That's right. You don't want the
Absolutely.
litigator.
And that's just it. And that was actually the appeal that I always made, even in a, healthcare organization, trade organization sense. Why would you be so academically talented to get into med school, residency, fellowship, and then let someone else from another profession shape your profession? In that sense, that was for advocacy. But in terms of employment contracts, it's the same thing. You have so much to lose. It's always most cost effective on the front end to allow any contract that you have bearing on your profession to go through legal sufficiency review.
Well, we appreciate your time today. This is one expensive period of
Yes.
time. We all have to get back to be billing, but we thank you.
And please like, share, and subscribe. We would appreciate it.
Thank you.
Thank you, Aimana.
See
Glad to
ya.
be part of the firm. Thanks so much.
Bye-bye.
Bye.
Bye now.